how to avoid common problems with your revocable living trust or revocable trust. So there are three common problems I see, and here's what you can do to avoid them. The first one is, of course, failing to properly fund your revocable trust, right? You come to a lawyer like myself, if you're in the state of Florida, and you ask for a revocable trust package because you want to make sure that your assets avoid probate. That's great. We provide you with a trust. And if you have real estate, we can help you deed that property into the trust. But what happens is we don't actually go to the bank or your financial institutions or your life insurance company and retitle those assets or change the pay on death beneficiary of those assets. That's something you have to do yourself. What we do is we provide you very detailed instructions on how to do this for each asset class. So for example, what you do with your revocable trust is you bring what's called the certificate of trust into your bank and you say, I want to retitle the name of my bank account into the name of my trust. So instead of it being in your personal name, it's in the name of your trust. Now the trust owns that bank account and you are presumably the trustee, so you have full control over what happens. There's no material difference in your life other than the name on the upper left-hand corner of your checks might look a little bit different, but otherwise you do whatever you want while you're the trustee. And then after you pass away, because the bank account is already titled in the name of your trust, the trust will indicate what happens at that point in time. With all financial accounts, you have the ability to either retitle the name into the name of your trust. And again, you bring the trust certificate, which is typically a 2 or 3 page document, to your bank officer, and they'll walk you through that process. Or you can change the pay on death beneficiary, right? Every financial account allows you to name someone who will, or a group of people who will inherit whatever is in that account when you pass away. You have the choice of either changing the name on the account, or you can keep the name of the account as is and change the pay on death beneficiary to, instead of being, let's say, the names of your children, put it in the name of the trust. The reason why you want to put it in the name of the trust is because if something happens to, in that example, your children, then you could invite a probate anyway, or you could unintentionally disinherit a grandchild, right? If their parent passes away and now all the assets go to the surviving child, well, the deceased child's children, your grandchildren, might not be entitled to anything. We want to avoid those sorts of things. There are certain assets where you cannot retitle the name on the account, like a 401k or an IRA or life insurance, but you can always name the trust as the pay on death beneficiary. The second problem that I want people to avoid is to assume when they set up a revocable living trust that it is going to provide them with any measure of asset protection. Irrevocable trusts, which is a subject for another video that I'll link to, irrevocable trust can provide you with asset protection, but revocable trust, the standard probate avoidance tool, is not going to help you avoid creditors. Okay? That's because typically you are the trustee, you are the creator of the trust, you're also the beneficiary of the trust. So if you're the trustee and you can control what happens with the assets inside that trust, there's no reason why a creditor can't come to you. Along the same token, because we do a lot of Medicaid planning, a revocable trust does nothing for you in terms of protecting your assets from being counted against you for Medicaid eligibility purposes. We have other devices that do that. So if you're interested in protecting your assets in a long-term care context, right, to get Medicaid to pay for home care, ALF care, or nursing home care, you can't rely on your revocable living trust. You got to call us, set up a consultation. We'll walk you through how to protect your assets the proper way. It's not going to be utilizing a revocable trust or a revocable living trust. Finally, a lot of people like the idea of a revocable living trust because while it cannot provide you, the person who's benefiting from the trust while you're alive, with asset protection, it can provide some asset protection for your children or whoever you name as a beneficiary to benefit from the trust only after you pass away. For those individuals or group of people, you can set the trust up for asset protection purposes, but the trust has to be very carefully written, because if you just instruct the trustee to make an outright distribution without any reservations, without what's called a spendthrift clause, placed in there, then you could inadvertently be subjecting your heirs to the whims of their creditors, right? Or if they get divorced, then their ex can take, can take half of what you're going to give them. Or if they have just problem managing money, maybe they blow that money. So if you're interested in protecting your heirs, typically your children, from themselves or risks to them, you want to make sure you're very specifically detailing those concerns with your estate planning, whether it's me or anybody else in Florida, to make sure that they're drafting your revocable living trust properly. So these are some of the more common problems I see people making, or assumptions that they make about their revocable living trust. Hope you can avoid them. We'd be happy to walk you through that process. If you'd like to give us a call today, schedule a consultation, we'd be happy to work with you. We help people all over the state of Florida. If you've liked this video, please give it a thumbs up. Please share it. That's how you help us get good information out to as many people as we can. Thank you for watching. Have a great day.